So maybe you're starting a business and you've thought of the perfect name for it, but you're wondering, do I need to do anything to secure this name? Or maybe you've already got a successful business, but you're launching a new product line and you've thought of the perfect brand name for it. But you're asking yourself, do I need to check to make sure nobody else is using this name? Or maybe your business is running along successfully and you're selling products or services, but you ask yourself, do I need to do something to make sure nobody copies my name or uses one that's confusingly similar to it? The answer to all of these questions is yes. You should check to make sure nobody has the rights to your name, and if it looks clear, you should file your own trademark application with the United States Patent and Trademark Office. Here are the reasons why.
The Trademark Office maintains a database containing not only registered trademarks, but also pending trademark applications. As soon as you file your application, it will appear in this public database. Companies that are thinking about using a new company or brand name will typically have their trademark counsel run some searches in this database to determine whether there are any names that are confusingly similar. If they uncover a pending application for a trademark that's similar to the one they're considering, this will typically discourage them from proceeding with that name. If someone files a trademark application after you for a name that's similar and for products or services similar to yours, the trademark examiner at the Trademark Office will usually issue them a likelihood of confusion rejection. This means the examiner believes that consumers are likely to be confused by the similarity between your mark and theirs. As a result, the person or company that filed their trademark application after you will be blocked, and they will not be able to proceed with registering their mark. Obtaining registration provides you with an official document from the federal government that you can use to enforce your rights against copycats. You can show the infringer you have a registration, and if they refuse to stop using the name, you can use this certificate of registration to take them to court to make them stop, and in some cases, pay you damages for their infringing activity. Though you can acquire rights to a name without a federal registration, these rights are weaker and typically will be geographically limited to the area in which you've been selling the goods or services. Obtaining a federal registration nationalizes your rights, such that you'll be protected across the country in all 50 states. Obtaining a federal registration also gives you the right to use the little circled R you see next to many brand names. This serves as notice and a warning to others that your mark is protected under federal law and that copying it would be illegal. If you're worried about foreign competitors importing cheap knockoffs of your products using your name, once you have obtained a registration, you can register this with the U.S. Customs and Border Protection. This will allow Customs to prevent these foreign entities from profiting off your reputation by stopping these goods at the border. Finally, if you plan on expanding abroad, filing the U.S. application gets you an early filing date, which you can use as a jumping-off point to secure trademark protection in other countries within a certain time frame.
So as you can see, there are a lot of reasons to quickly get a trademark application on file at the U.S. Patent and Trademark Office for your name. If you need help with any part of the process, you can reach out to us at Forge IP, a law firm that specializes in patents and trademarks. You can reach us at trademark@forge-ip.com if you have any more trademark questions or if you'd like to get a copy of our pricing sheet of standard filing costs. We hope this was helpful, and we wish you the best of luck in protecting your name.